All right, everyone. Hi, good morning. Hope we all did well in the snow. I'm here with Britt Berner with Berner Prudenti Law, and she's going to chat with us about new estate planning for 2026. So take it away, Britt.
Thank you. Hi, everyone. Thanks for joining. My name is Britt Berner. I'm the managing partner of Berner Prudenti Law. We are an estate planning, elder law, and real estate firm with offices from Manhattan all the way out to East Hampton. And I love to come talk to the library, talk to everybody here about different topics relevant to your own planning that we help people handle and have for over 30 years. So we're going to talk about 2026 estate planning. So a lot of these topics are things that you might have heard before, we've talked about before, but we're really going to just update maybe some information that has changed over the past year. And it's really a reminder, new year, let's buckle down and get the planning done. As Sarah just put in the chat, if you do have questions, feel free to write them into the chat, and I will go in and answer the questions at the end. So to get started, something that hasn't changed, but something that everybody should have in place are what we call advance directives. These are medical directives where you state what your wishes are for if you were to become in a state where you couldn't speak for yourself. So first and foremost is the healthcare proxy. Every person 18 years and older should have a healthcare proxy. This is a document that says who makes medical decisions for you if you cannot make them for yourself. Now, if you are in a state where you cannot speak to the doctor because of a long-term or a short-term incapacity, right? It could be that you're under anesthesia, or it could be something more long-term, like a cognitive impairment that's not expected to get better. You want to at least know that the person that you've empowered to make decisions for you is going to make decisions similar to how you would make them for yourself. So, for example, there's I should say that there is one person at a time. So you may have two children and you want them to work together. That's great. You can tell them your intention is for them to work together and you want them to run things by each other and use each other as a resource. However, the document must have one at a time. So you could list one and the other as a backup. The reason is that you need to make sure that there is a primary decision maker and communicator with the medical staff. If you are in a facility, meaning a hospital, a nursing facility, or a rehab, and you do not have a healthcare proxy in place, there's a law called the Family Healthcare Decisions Act. This is a default, right? So, this is the law that says if you don't have a healthcare proxy in place, who makes your decisions? And your spouse is in the first instance, then it would be your children, your parents, if you don't have a spouse or children, your siblings, and it goes down a list, a hierarchy. Now, the person who is the default person may not be who you choose. So, for example, I've had people come to me and say, I don't want my spouse to be my healthcare agent because we have differing beliefs about life support, or because my spouse loves me too much and they would never be able to make that really hard decision for me. Or obviously the opposite could be true. So people like to have a healthcare proxy that they have chosen, not just that's the default. Also consider if you do have multiple children and they are all at the same level for default, there is no primary decision maker. There's no clear person. And you want to make sure that you're picking the person who would choose as closely to what you would choose if you had your voice and could say what you wanted. You also want your healthcare proxy document to state that your agent has the right to make decisions regarding end of life and artificial nutrition and hydration, because we want to make it very clear that this person has all decision-making capacity, not just smaller decisions like whether or not to administer a medication. So that's the healthcare proxy. You need two witnesses. They have to be over the age of 18 and not the individuals you've named in the document. And you can have any two people. You don't need a doctor, you don't need a lawyer, you don't need a notary. My first healthcare proxy was signed in a hospital. I was about to have my appendix out, and the nurse was one witness, and the person sweeping the floors, because it was about midnight, was the other witness. And they actually had the New York State forms on hand, and I picked and signed it at the time. So it's very important to do that so that you have control over who has those decision-making authorities. Now, this document can last indefinitely, so it does not expire. You can say that it lasts for an indefinite amount of time, but you can also change it as things change, or you change your mind, or there's different people that you're living near. You may live near one child and then you move near the other child, and so you want to change who the healthcare proxy is because that's who's responding should there be an emergency. And you can certainly do that. But absent a change or a revocation, it remains in effect in most cases. Along with the healthcare proxy is the living will. A living will states who will be able, sorry, not who, but if you are in an irreversible state with no reasonable expectation of recovery, whether or not you allow your agent to withhold or withdraw certain treatments. So you're not making any decisions in this document. It is signed, again, it's an advance directive. It's signed when we don't have a lot of information, right? So you sign it in advance of needing it, meaning we don't know what your illness will be. We don't know what your comorbidities will be. We don't know what treatments will be available. You're really just signing a document to say that you're leaving it in the hands of your agent to make those decisions regarding potential end of life treatment. And then it's important that you then have a conversation with your agents to let them know these are the things that I would want or not want. So those are the advanced directives. We often also sign a HIPAA release. HIPAA is the law that gives you privacy over your healthcare, your medical information. And signing a HIPAA release is just saying who can receive information regarding your medical treatment. And that is an information. It's for information gathering. It's not for decision making. Another document, which is not healthcare related, is the power of attorney. This is financial. In some states, they have medical powers of attorney and financial powers of attorney. In New York, we have the healthcare proxy, the living will on the healthcare side, and then the power of attorney on the financial side. The power of attorney document is a document that allows someone to step in your shoes and handle things that you can also handle for yourself. Unlike that healthcare proxy and the living will, which are for when you're incapacitated, a power of attorney is not necessarily for when you're incapacitated. You can have full capacity and grant a power of attorney to another person who has duplicate powers to you, but you can still do things on your own. So, a lot of people, there's a gray area of time where maybe you're still functioning, you're doing some things, but maybe you need help with other things or you want help with other things. You can empower someone through the power of attorney to handle those things for you. Um, the power of attorney document, if you signed it before June of 2021, if you have an existing document, you should probably have it looked at because in June of 2021, there was a new power of attorney law that went into effect. It created a new New York State form, and before that time, your document will still be valid as long as it was valid when you signed it, but that doesn't mean you might not want to update it. So you should have it looked at to make sure that it has everything you need. Importantly, the power of attorney has powers that we refer to as gifting powers. And we often want to grant gifting powers because gifting in the New York State power of attorney context includes any transfer of assets out of your name. So that could be from you to your spouse, from you to a trust for your benefit or the benefit of another. It can involve Medicaid planning. And it can also involve estate tax planning. So if you want your power of attorney to be able to make those types of transfers for you, you want to make sure that the power of attorney includes gifting. Um, you will want to talk about the gifting powers with a lawyer and make sure that you understand the authority that you're giving and then grant those authorities. Unlike the other documents, not only are there two witnesses, but you also need a notary with this document. The notary can be one of the two witnesses, but you do need to sign it in front of a notary public. And after you sign it in front of the notary public, in order for your agent to act with the document, they also need to sign it in front of a notary public. And then the document's fully in effect. So some people sign it and hold on to it, and they say to the individuals they've named, listen, I've named you as power of attorney, and the document's in my top right-hand drawer or wherever you may be keeping it. And if something should happen to me, you should go and get it and sign it in front of a notary, and it will be in effect. But right now, I don't need your assistance, and so I'm going to hold on to the document. That's another conversation you should have with your lawyer when you sign the document is where should it be kept? Who should I be telling about it? And how far should I go in this execution in terms of me signing it, the agent signing it to make sure it's in effect? It is really important to have a power of attorney in effect as long as you have someone that you trust to name, because it will possibly avoid a guardianship situation. If you become incapacitated and you don't have anyone who's able to access your assets for you and pay for things and take care of things, your family could end up in a lengthy and expensive and intrusive guardianship. And so we want to try and avoid that. Moving on, let's talk about what is a will versus a trust. So, a will, a last will and testament, is a document that says, when I die, this is who's in charge, that's the executor, and this is how I want them to distribute things, and all the terms are laid out. In order for that person to be appointed as executor, and in order for those distribution standards, the things that you say that you want to happen, to be carried through, the will must go through a court process called probate. So, probate is the process of determining that the will is valid, that the executor is appropriate as one, appoints the executor, and gives them the power to carry out the terms of the will. Now, all wills go through probate if they are to be followed, and that's if there's assets in your sole name with no beneficiary. So if you have everything joint with rights of survivorship with your spouse and your retirement accounts name your spouse as beneficiary, well, then when you die, there's not likely to be any probate proceeding and your will won't mean anything because all the assets are going to go to the joint owner, your spouse. However, let's say you, and I just had this, someone passed away and everything was joint with the spouse, but there was one account that they thought had a beneficiary and it didn't, and it was about $75,000. So the will be probated for that one $75,000 account. Everything else will go according to the beneficiary designations or the ownership designations, but that one account is going to pass through the will, and so probate will be required. Now, what is probate? What is the process? So, the original will, the original signed wet ink will be signed and put to it was submitted to the court with a petition for probate, asking that the executor be appointed and that the will be admitted, meaning that the will be rubber stamped by the court that it's valid. Notice of probate needs to go to all of your legal next of kin. So, if you are a person who has two children and you're disinheriting one of them, the child that you are disinheriting is going to get a copy of the will and a notice that says that the will is going to probate. And they can either sign a waiver saying, I'm not going to fight it, or they get a citation that says, come to court on this day and tell the court why you think that this shouldn't be done this way, why this will shouldn't be followed. And a lot of times when people are disinheriting someone, they want to avoid that because that individual could come to court and maybe they don't have a good reason, but they come to court and they make a mess and they make a fight for their other sibling who just pays them to go away. And they figure, well, I got more by being paid to go away than I would have by being disinherited. And so I came out on top. So if you're disinheriting those legal next of kin, you want to make sure that you're avoiding probate. Also, if you don't know who your next of kin are, I have people who come in and say, I'm very easy. I am not married. I have no children. I'm an only child. My parents are deceased. And what I'm thinking in my head is red flag. This is a probate problem because I need to know who your next of kin are because I have to give them notice of probate. And so if you say, I think I had some first cousins, but I don't really know. We never really saw them. My parents didn't really have a relationship with that side of the family. And so I don't know who they are. That can be a very expensive process for probate because we have to identify those people. We have to get a genealogist to say who they are and where they're likely to live. And so we want to avoid probate if we don't know our next of kin. We also want to avoid probate very often when there's a disabled or a minor beneficiary. I have someone right now who one spouse died and the other has cognitive impairment, a type of dementia that they've had for over 10 years, is unable to sign anything or represent themselves, and therefore they can't sign off on the probate. And the court wants to appoint a guardian to represent the individual in the probate proceeding. And that can just be a delay and a time, a waster of time in this case. So it would be helpful if we avoid probate when there's a disabled or a minor beneficiary that the court deems is unable to represent themselves. We also want to avoid probate when there's out of state property. So, say I live in New York, New York's my primary residence, but I also have a house up in Vermont. Well, then my will is going to have to be probated in New York because it's my primary residence and in Vermont because I own a house in my name in Vermont. So, I'm going to want to avoid probate if I have out of state property because that's actually avoiding two probates. Um, and then anytime we have a situation where we're doing tax planning, where there's trusts that continue on, if you're leaving assets to your spouse or your children in a trust, we often want to avoid the court involvement because of delay and because of complication going forward. So then that begs the question, how do we avoid probate, right? So we talked about why we might want to avoid it. How do we avoid it? Well, one, we name beneficiaries on things. So, for example, your IRA can have a designated beneficiary. We can have joint owners. So, you could own your house joint with rights of survivorship with your spouse or with somebody else. Um, we can have a trust. And a trust is a document, just like a will is, that says, when I die, this is how things should be distributed. But the difference is a trust owns things while you are alive. So if I said that a will goes through probate when there's assets in your sole name with no beneficiary, well, if your assets are in the name of your trust, not your sole name, we avoid probate. And the trust privately determines how those assets are distributed without all of those notice requirements. I want to stop just to mention that there was a law that was recently passed in New York for electronic wills. There will be a mechanism for wills to be signed via the computer. It's not the subject of today's talk, but it is something that you'll start to hear more about and we will be talking about. It is not going into effect in the short term. There's a delay, and so we have a little bit of time. And there's obviously some concerns because we want to make sure people have the capacity and they know what they're signing. But if you do see things about electronic wills, know that it has been signed into law in New York, but it is not yet in effect. So now let's talk about trusts. So I'm going to talk about two main types of trusts today, although there's a lot of different types of trusts. So first, I'm going to talk about irrevocable. And a specific type of irrevocable trust I'm going to talk about is an irrevocable trust for Medicaid asset protection. Now, the word irrevocable in this context really just means that there's some limitation on you as the creator of the trust in exchange for some kind of a protection. So, in the terms of the Medicaid Asset Protection Trust, there are certain limitations on your control and access. And the benefit that you gain is that the assets in the trust don't count for Medicaid eligibility purposes. For in New York State, for home care Medicaid, we currently have no look back. That means that if in the month of January I transfer assets to a trust, if I apply for Medicaid for home care on February 1st, those assets will not count as my own. I still tell Medicaid about them and I tell them the trust exists, but they will not bar me from eligibility. For a nursing home, we have a 5 year look back. So that means that if I put assets in a trust in January, I need 5 years to elapse before those won't be considered my asset for eligibility purposes. And so we like to do advanced planning when that's the type of protection you're looking for. Now, New York State in 2020, April of 2020, so we're going back quite some time, had a law that was part of the budget that year that said that there'd be a 2.5 year look back for home care services. That was signed into law as part of that budget. However, it's never been implemented and it doesn't currently have approval from the Center for Medicaid and Medicare Services, the federal government. So it's in limbo. So right now, there is no look back for home care Medicaid as long as you're eligible on the first of the month in which you apply, you are eligible. So that is why we do the Medicaid Asset Protection Trust. Now, what are we giving up, right? So you can't be the trustee of the trust. So you can't have management or control over the trust assets. But you can, and your spouse also can't be the trustee. However, you can name a different family member, a friend, and you have the right to change that trustee. So I always tell the child or the adult child when they're signing the trust, if you go rogue, mom or dad can remove you, right? Because you keep the power to change the trustees. You keep the right to live in your property, keep all your property tax exemptions as they are, get the step up in cost basis upon your date of death. If you sell it during your lifetime, you get your personal $250,000 exclusion from capital gains taxes. It's all as if it's yours because it's what we call a grantor trust and you can have all the income. So if you have a property in there and it's earning rental income, you can receive the rental income. But you cannot have access to principal. So if I put $100,000 into that trust, you can get the income and the interest earned off of that $100,000, but you cannot get the $100,000, the principal, because that is what protects it for Medicaid. And it makes sense because if you could have access to that principal, Medicaid would say, great, then go use it for your care, right? So it's the fact that you don't have access to it is what protects it. You can name other individuals as lifetime beneficiaries of principal. So let's say you name a family member as a lifetime beneficiary of principal, they can have access to that principal, but you cannot, and it cannot be used. The trust states that that principal can't be used to pay your bills. So you're still the house may be in the trust, but you're still paying all the maintenance, the upkeep, the taxes, etc. That's an irrevocable trust. Now, the other type of irrevocable trust that we often talk about is a trust for estate tax purposes. So, a grantor trust is one where that I just described, the Medicaid trust, where it is part of your estate. For all tax purposes, it's still your property. The other type of irrevocable trust is a non-grantor trust. And for that trust, the purpose is often to remove it so it's not part of your taxable estate. And I'm going to explain what that means to have a taxable estate in 2026. But to remove it from your taxable estate is someone who's over these exemption limits. So these are for the wealthier individuals. So federally, this year, there's a $15 million estate tax exemption per person, which means 30 million for a couple. You may remember that last year we were at about just under 14 million, and the law was going to sunset. And when the law sunset, we were going to go back to around 7 million, where New York was. But when the president signed the bill on July 4th that did a lot of different things. One of the things that it did was it expanded the federal estate tax exemption to a permanent 15 million index for inflation. So if you go over the 15 million, there is a tax on the overage. However, if you're under the 15 million, there's no estate tax. And it is what we call portable between spouses. So if one spouse dies and all the assets go to the survivor can file an estate tax return saying, I got all the money. I didn't use any of my spouse's 15 million exemption. When the second person dies, they have their own exemption plus the 15 million that was left from the first spouse. So it's really a shared 30 million. That's not going to be the case, as I'm going to explain in New York, but that is the federal. The federal government also has a gift tax amount. So in a given year, you can give any one person, as many people as you want, up to $19,000 gift tax free. So if I give everybody on this webinar $19,000, no tax filing, no tax owed. If I give everybody on this call $29,000, that's a $10,000 taxable gift to each person. I would file a gift tax return for that gift, and it would set against my lifetime exemption of 15 million. So if my entire net worth is $1 million, I can never give away enough to actually have a gift tax be owed because that 15 million that I have is for lifetime and at death gifts. It's cumulative. So when you're outside of New York State, a lot of people are not so stressed about estate tax planning right now because they figure, well, between me and my spouse, I have $30 million and we might be doing okay. We're very comfortable, but that's a very high sum and we don't come close to that and we don't have to worry about estate taxes. But here in New York, we do. We have a stricter rule in some regard, and we need to make sure that we're paying attention. So if the real key takeaway on this tax stuff is if you and your spouse, or if you're a single person and you add up the estate and it's at or around 7 million, you should be talking to a lawyer about estate tax planning. And this is why. New York State has a personal exemption of 7.35 million in 2026. So I can have 7.35 million and my spouse can have 7.35, but it's not portable. So with the federal government, with the right tax filings, you could die with over 30 million of exemption because you have your own spouse, your own exemption and your spouse's. In New York, it's use it or lose it. So if one spouse dies and all the assets go to the survivor, and then the survivor dies with an estate over 7.35 million, there will be a New York estate tax. And so it's very important if you're at or around that amount that you're looking into planning. New York also has what's called a cliff. So when you hit 105% of the exemption, you fall off the cliff. So 105% gets us to $7,717,500. And once you hit that number, if you're $1 over, then your entire estate is taxable. There is no exemption, and you're taxed at that. It's the highest tax in New York is 16%. When you're right at the cliff, you're probably between about 9%, 10%. So you're saying you're going from not having a tax at 7 million to when you have 7,717,501, you're probably talking about, maybe about almost $800,000 in tax right off the bat. So you really want to make sure that you're watching for the planning. Now, what you can do is when one spouse dies, the assets can go into a trust that captures the first spouse's exemption, and then the rest of the estate is taxed when the second person dies. And that's how we use it and still leave it available to the surviving spouse. Now, one of the good things about New York is that New York has a no gift tax rule, which is great, right? So we don't have to worry about those $19,000 gifts. So if I give away $1 million, as long as I live for 3 years after giving that gift, it never counts. So if I'm at 8 million and I give away $1 million and I die 3 years and one day after I gave away that $1 million, it does not get clawed back into my estate and I die with $7 million and there's no tax. But if I die before that 3 years, the value gets clawed back. The actual gift doesn't get clawed back, but the value does for the purpose of estate taxes. It will be as if I died with an $8 million estate, and the taxes will have to be calculated. So you want to be thoughtful when you're giving gifts that yes, New York doesn't have a gift tax, but we want to make sure that that we're doing this in a thoughtful way where we're living beyond the 3 years, especially if you're doing it for estate tax planning purposes. We often put a disclaimer to charity in documents. So let's say somebody is at 8 million. They can have a disclaimer in their documents that says, if my beneficiaries decide within 9 months of my date of death that they want to give money away to charity, they pick how much, but I'm picking the charity. So let's say my charity, it has to be a 501(c)(3). Let's say it's the library. So my documents will say, if my beneficiaries disclaim, the disclaimed share will go to the 501(c)(3), the library. And then upon my death, if my estate is calculated and my family says, Well, if I've got $300,000, we're it's not really 300, it's like 280,000 and change over the cliff. Let's give that 280 to the library, and then we're not going to pay the $800,000 that we would owe in taxes. And so we've benefited a charity, and we've also benefited my beneficiaries because there's less out of their pocket, and they're not paying a tax on it. So that's how a disclaimer to charity works. You just have to pick the charity now. Again, if you're close to this 7 million number, even if you add you and your spouse together, these are the kinds of things that you should be talking about with your attorney to make sure that you have it in there just in case, right? Because 7 million today with the growth of a value of a real property or growth of a portfolio of investments, you could get over that taxable amount before your date of death. And so you want to pay attention and have these procedures in place, or these mechanisms in place to potentially protect. And then, like I said, you could also do the lifetime gifting if you're really only worried about New York. Will get you back under that number by gifting during lifetime and living for 3 years beyond that gift. One thing I do want to talk about specifically is when you have a piece of real property. So, say you've got that beautiful estate on Shelter Island, that house that's been in the family for so many generations, and everybody loves going there and everybody wants to keep using it. And you have several children. Well, do we want the documents to say that the family property remains in a family trust and can continue to be used by the family, right? And then the question becomes, what other assets are in the estate? Do we need to put a bank account into this trust as well after your death so that there's money to keep the house going? If there is not the availability of funds like that, who's going to keep paying the bills? Who's responsible? Who's the trustee? If the house is eventually sold, who are the beneficiaries? I've gone as far as to put a schedule of how many weeks of the year or of the summer each family member gets alone in the house and then also as shared time. So every family is going to be different. And I find that when these conversations are had in advance, where everybody's on the same page and understands what the rules of this shared property are going to be, things tend to work out a lot better after death. So, we always say clear is kind, right? We want to be as clear as possible with these assets. And when you create a trust and say, upon my death, this property that's in my trust will continue on in trust, and this is who's in charge, and these are the rules, and this is how things are paid for, it makes it a lot easier for those you're leaving behind. You can also do something called a right of first refusal. So you may have two children, and one lives on the West Coast and one lives on the East Coast, and the one on the West Coast barely comes home once a year. Well, maybe you want to give the one on the East Coast the first right to purchase the property from their sibling. And so they can buy it, and you determine what fair market value will be. Are there any discounts for being an interfamily transfer, etc.? What makes you feel comfortable? And then you can give that right of first refusal in your documents to say that these assets can be given to that this one individual can buy the property out from my other family member. And maybe there's enough money in the estate that the family member that buys the property just gets less of the cash or something else. Or it might be that they actually have to use their own funds and buy the property. They may have to get a mortgage depending on what the deal is. How long do they have to determine? How long do they have to secure the mortgage if that's the way they have to go? These are all things that, if contemplated in advance in a very open environment, often can create a situation where there's less litigation and fighting on the back end after you're gone. So your family members know what you wanted, what you intended, and everybody's on the same page. Now, obviously, with some families, you can do as much as you can, and no one's ever going to be on the same page. And that's the case. But even more reason why you would want the documents to be as clear as possible to try and make litigation less of an issue after you're gone. Another type of assets we really want to talk about are retirement assets, right? So if you have a 401k, an IRA, a 403b, these tax deferred investments where you earned money, you never paid tax on that money, it went into an account. When you retired, maybe you rolled it to an IRA or whatever it is. And now, after once you have to start taking distributions, you take your required minimum distributions. You pay ordinary income tax on those distributions. It's the first time tax is being paid on that money. Well, when you leave those assets behind after you're gone, unless you're leaving it to a spouse or a disabled beneficiary or a few other small categories, for the most part, when you leave with those assets behind, there's a 10-year required payout. So if I have 2 million in retirement in an IRA and I die and I name my daughter as the sole beneficiary, she will have to take that $2 million over the course of 10 years after my death as ordinary income. And so you just want to think about that in terms of when you're dividing up assets and you're determining how things should go. You one definitely want to be very specific about who your beneficiaries are on those retirement accounts. And you also want to think about the tax consequences. And that's something that you should be talking about, not just with your attorney, but also with your financial advisor and your accountant to make sure that you're being as tax efficient as you can be. Um, that 10-year payout is something that changed again at the beginning of 2020. It was called the Secure Act, and we've actually had updates to the Secure Act since that time. But that was a federal law that was signed regarding that 10-year payout. And that's a big change because prior to that, so if you have a loved one maybe who died in 2017, 18, 19, or any time before that, when you inherited their retirement accounts, you were able to roll it over and take it over your life expectancy. So if you were 40 years old, you would have maybe 50 years that you could take it out over, and it would continue to grow tax deferred. Whereas under the Secure Act, it's this 10-year payout. So it's fairly punitive if you have large retirement accounts and individuals who are going to have to claim that as ordinary income. And if it puts them into a higher bracket, it's going to put them in a higher bracket for all of their sources of income, not just for that one piece of income. So you want to be thoughtful about your beneficiaries. Also, if you are charitably inclined and you know you want to leave beneficiaries that are charities, then you may want to think about leaving retirement assets to charitable beneficiaries. Because if I was planning on giving $500,000 to the library and I leave them instead an IRA worth $500,000, I name them as beneficiary on that IRA, the library is not going to pay income tax on that money, and that's going to be a full free and clear 500,000. So it's beneficial to the library as beneficiary because they get the full amount, and beneficial to your estate because there's no taxes being paid, and your other people that you're giving to can receive other assets that are not going to have these income tax consequences. So you want to be really thoughtful when you have different categories of assets. Um, this brings me to talking about when you meet with your attorney. When we meet with individuals to discuss their estate planning, I don't just need to know, are you above or below 7 million, right? That's one thing I need to know. But I need to know what that 7 million is made up of. Is it real property? Are there mortgages on that property? Is it investment accounts? Is it retirement accounts? Is it cash? Is it corporate ownership, non-qualified annuities? What makes up your asset list, and how do we best plan with the assets you have? People often say, well, my neighbor did it this way or my neighbor did it that way. And if you actually look, well, your neighbor may have very different classes of assets. They also might have a very different family structure. And so you really want to make sure that you're being most efficient for your assets and your family members and your intended beneficiaries. I'm going to stop and see if there's any questions.
We do have one. We've got one that says no tax on IRA for surviving spouses.
Oh, sure. I think that I was maybe misunderstood. When if I die and I have an IRA and I have my spouse as beneficiary, my spouse will roll it over. And when my spouse takes distributions, my spouse does pay income tax on those distributions. The difference is my spouse is not stuck with the 10-year payout. So a spouse, a chronically ill beneficiary, a disabled beneficiary, a minor beneficiary, and a beneficiary that is within 10 years of your age are exempt from that 10-year payout. So there is still, and in terms of estate taxes, anything that goes to a spouse gets, as long as your spouse is a US citizen, gets a full marital deduction. So you could leave $100 million to your spouse and there'd be no estate taxes. The question is just, without the planning, what happens at the next, at the spouse's death. But your spouse will have more years, not be stuck to that 10-year payout. Any other questions?
It looks like we're good at this time.
Okay, great. Um, Let me see what else I haven't covered. So I think that covers the bulk of what we were going to talk about today. I mean, 2026 is the real big changes are those estate tax numbers. And then we will eventually see those electronic wills coming in. And stay tuned, we will do a program specifically on the electronic wills. Um, Maybe with the library or otherwise through the firm, we'd be happy to do it for the library. And really, the key is it's the beginning of the year, and it's a good time to look into your estate planning if you've never done it, or also to review what you've done in the past and make sure that it still makes sense. Because a lot of times people set it and forget it, right? You do your estate planning, you put it in a drawer, you don't look at it. And when you actually open it up and take a look at it, you might not have appropriate beneficiaries any longer. You may not have appropriate fiduciaries, meaning trustees or executors. You want to make sure that it's up to date. Also, your assets may have changed quite a bit. I have a lot of people who are coming in now who their assets have gotten much more complicated over the course of the last 5 or 10 years just by the fact that they've earned more or that their assets have grown in value. Maybe their property has grown in value, as we know many have on the East End. And so it's really important to be looking at your estate planning every 3 to 5 years to make sure that it's still in order. It's very possible no changes will be necessary, but it's definitely something you should be looking at in that time frame. Every 3 to 5 years is my best recommendation on that. And when you're sitting with an attorney to talk about your estate planning, you should really be talking in detail about every single asset you have and what you should be doing with it. Because as you can see from what we discussed, if you're not talking about all of the assets, we can't understand the tax implications of all those assets and also the implications for how they'll be distributed at death if we're not accounting for them in the planning process. And some people have some assets in a trust and some that pass by designation or some assets that will pass through their will and some that won't. And it's okay to have a mixed plan as long as it's part of your plan. I'll pause one more time for questions and then we'll be all set.
We've got, if you have a trust, what is the difference from naming beneficiary versus leaving to trust?
Sure. So it's going to depend on who your beneficiaries are. So, for example, if you have a trust and you know you want a certain amount to go to a charity, or a percentage to go to a charity. I'd like to talk to people about how to leave to charities because if you say $500,000 to the library, then in your trust document, then the trust assets will be used to make that bequest. If you on your retirement account name the library as the beneficiary, it'll go directly to the library. However, if you say that the library gets 5% of my residuary estate, meaning 5% of the assets in the trust or in a will, then you create an administrative nightmare because the Attorney General of the state of New York will there will have to be an accounting to the Attorney General because they represent the interest of the charity. So naming a beneficiary versus having everything flow through the trust has its pros and its cons depending on what the assets are and who the beneficiaries are. Now, if you have a family member and you want to leave them, if, for example, a spouse, and you really want your spouse to have the assets upon your death, you can name the spouse directly as a beneficiary. However, if you and your spouse fall in the category as being over that estate tax exemption together, the 7.35, then if everything goes by beneficiary designation to your spouse, I've lost the opportunity to plan and use your exemption at the first death. So in some cases, naming a beneficiary directly is going to be totally fine. But then in other cases, and those are just two examples, we are going to want the assets to pass through the trust so that we can take advantage of other planning. Also, if you have a beneficiary where you want the assets to go to them in a trust, say you want to leave assets to your child in a trust where they're protected from creditors, divorcing spouses, estate taxes upon their own death, etc. Well, then you don't want to name direct beneficiaries. You want it to pass through the trust. So it's going to depend on how you intend to leave things, which way you want to go. If that didn't answer your question, feel free to ask a follow-up. Right, I think we're okay then. Anyone else? Nope. Oh, interesting. So there's a question here. Connecticut residents with a house on Shelter Island, what considerations to be aware of? So your estate planning should be done in Connecticut because you are Connecticut residents with an attorney there. But you fall in the category of you probably want to not have a will and you want to avoid probate. You probably want to create a trust because as a Connecticut resident, your estate would have to be probated both in Connecticut and in New York because you own real property in New York in a state separate from your primary residency. So you could create a Connecticut trust that owns your assets that you hold in Connecticut or wherever else, but also that you deed the Shelter Island property to that trust. It doesn't have to be a separate trust for the property. It can be in that same trust, but you want to be discussing avoiding probate to avoid two court processes upon your death. Any other questions? Great. All right, I think we might be good.
Yep, looks like we're good.
Great. Thank you everyone for joining us. Stay warm, stay inside, and have a good day.
Thank you so much, Britt. We appreciate it. And we'll definitely be in touch about those electronic wills. That sounds
Yeah,
interesting. Yeah, yeah. All right. Thank you so much.
thanks. Bye.
Bye.